In their motion filed on December 10th, 1992, the defendants argued that the information set forth in Baranski's complaint was newly discovered evidence of great significance. This motion claimed that the information constituted Brady material, of which the prosecution knew or should have known, either directly or through its agents. Defense counsel charged the government with misconduct and argued that during his testimony, Baranski had concealed his relationship with law enforcement authorities and his compensation arrangements concerning the seized money. The remedy, defendants urged, was either dismissal of the case or a new trial. A flurry of further filings followed. The prosecutors denied that they or the case agents assisting them had during the trial any knowledge of an arrangement between Baranski and the state police for him to cooperate with law enforcement authorities. The government also argued that the additional impeaching effect of such information, if true, would not conceivably have altered the outcome of the trial given the limited role of Baranski's testimony and the parole of witnesses against the defendants. Defense counsel filed a broad-gauged motion to produce, including all materials related to any agreements with Baranski or no as to the return of the seized money. On February 25th, 1993, the district court denied the motion for dismissal or a new trial. It ruled that the record provided as adequate basis for resolving the motion was sufficient. The court pointed out that No had testified at trial and disclosed the search of his business premises in the February 1988 raid. Since the records of the raid were sealed, and the court said that the defense counsel, knowing of the raid, could have secured and the information about the court, declined to describe the evidence as newly discovered, implying that due diligence by defense counsel would have uncovered the information in time for trial. The court also said that Baranski's own trial testimony had shown him to be a witness of dubious credibility. Such dubiety provided by the Baranski state court complaint was at most additional impeaching evidence. The court said that the additional evidence, if presented to the jury, would not likely have altered the outcome of the trial, so that the defendants had failed to make the minimum necessary showing for a new trial. Indeed, the district court indicated that there was no reasonable possibility that the evidence would have had an altering effect. We agree with the district court that even the complete discrediting and elimination of Baranski's testimony would not have changed the outcome in this case, and that alone is basis enough to affirm the court's denial of the motion. The defense may have a plausible argument that even if a diligent pretrial search had uncovered the state police records of the search and seizure of the funds, these facts would not have disclosed the supposed work-it-off arrangement alleged in Baranski's complaint. Nevertheless, as we explain below, new trials based on newly discovered evidence or on evidence withheld by the prosecution require unspecified showings as to the likelihood of a different result. The defense has not made these showings. We start by putting to one side any claim that the government engaged in deliberate misconduct. The prosecutors represented that neither they nor any of the case agents were aware of any deal between Baranski and the New Hampshire authorities. Pretty good.
Yeah, I think so. Mr. Cohen, you have some one-sided paper or
Yeah.
paper, you know?
I have some